Good morning, everybody. We're
Morning.
bang on time as usual. Um, welcome to what is our third webinar session for those that are keeping score. We started these at the tail end of the summer. They run pretty much every 6 weeks or so. We're going to take Christmas off, but there is another one planned for the new year as well. And they're really aimed at just sort of sharing good advice and information around HR issues which are relevant and topical. Brought to you obviously by ourselves. We're Index eBusiness. We're a software company. We specialize in HR software. And today, obviously, joined by one of our HR consultant partnerships, the good people at Target HR. And then specifically Luke, who's going to talk to you obviously about equality and diversity today. I'm going to join the session a little bit later, or come back into the session a bit later, just to share with you some specific features in our software which can help with the issues that Luke is going to talk about today. If you're ready, if you're happy, Luke, I'm
Yeah,
happy to hand over to you, and I'll join you in about half an hour's time again. Cheers.
fantastic. Cool. Right, let me share my screen. Yeah, hopefully you can all see that. Morning. So yeah, as Steve said, my name is Luke Potton. I run a company called Target HR. We help SMEs with HR advice, training like today's session, and general guidance on people issues and employment law based advice. So today's session we're talking about equality and diversity. Essentially, we're going to be talking about the Equality Act, what it covers. Essentially, the purpose of it is protecting individuals from less favourable treatment and suffering any disadvantage due to a characteristic that they have that they can't necessarily control. All workers are protected under the Act almost from before employment, really from the first moment you engage with this individual, from the recruitment process, even into first day of employment, all the way through they're protected under this Act. They don't necessarily need to show that your motive was necessarily discriminatory in order to make a claim, almost that they've been treated less favourably or differently. And actually, if you can't show some objective reason as to why they've done so, it's very likely they'd be successful. It's probably my favourite area of employment law, just because I think it's a really important area and the stakes are very high. So what we'll be talking about for the next sort of 40 minutes or so, hopefully you'll understand what equality and diversity is, and we'll talk about the benefits of having a diverse workforce. Hopefully you'll get a pretty good understanding of discrimination law and its impact in the workplace. Actually, how a lot of discrimination can be unintentional, and it can be based on good intentions and often just an ignorance of the law, and should have the skill set from this to be able to sort of recognise discrimination and harassment. We'll be talking about what that looks like in the workplace and what you need to do about it as an employer. Actually, I'll be talking about lots of real case examples of where employers got it wrong. So when breaking it down to basics, when we talk about diversity inclusion, essentially diversity is having a workforce that's made up of people from a variety of different backgrounds, people with different protected characteristics, which we'll be talking about. And when we talk about inclusion, really actually is how individuals from different backgrounds feel in the workplace. Actually, how inclusive is your workplace, how it recognises and appreciates those individuals and the differences, and actually ensures that there's equal and fair opportunities for all of them. So we talk about some of the benefits then of a diverse workforce. Obviously, it brings in new ideas. People come from different lived experiences, different backgrounds. The way they approach a problem, the angles that they attack it from can be different. Whereas if you had a workforce of all the same types of people, you might not get those new ideas. Also, a diverse workforce, your employees can reflect and relate to a diverse customer base. So actually they can engage and build rapport with people of different backgrounds. As I said, it brings more creativity and innovation. My background is hospitality management, and often in kitchens, when we were looking at menus, we have employees from all different backgrounds, and their experiences with cooking and culinary would really help with those menus. Actually, if you do have a diverse workforce and you shout about it, you're more likely to attract more talent from people that actually feel, okay, I'm going to be included in that workplace. Actually, there was a study that showed that diverse workforces who focus on racial and ethnic diversity are 36% more likely to have better financial returns in their industry. So yeah, strong evidence that a diverse workforce can boost your profitability. Finally, and potentially most important, actually, is it reduces your legal risk, where your team and your employees have a better understanding of different cultures and different backgrounds, and then less likely to act in a discriminatory way. So actually, how can we make our workplace more diverse? Well, actually, when we're recruiting, we need to ensure that our pool is wide enough, and that we're fishing in the right seas in terms of our adverts being accessible to all places where people might look. Making sure that the interview process is clear, and actually that we're opening ads up to everyone. We're not recruiting down with our mates at the golf club. Actually, the selection criteria and process that we're doing is fair, and we're using objective criteria. One thing you might consider is using CV blinding, which actually is where initially you'll remove names or any reference to education locations so far, to try and reduce any unconscious bias that the managers might have when looking at CVs and making assumptions. And finally, actually giving staff training, being more aware of the Equality Act and diversity, so that individuals from all backgrounds do feel welcome in your workplace. So the Equality Act sets out protection for workers and employees and individuals from discrimination. But what actually is discrimination? It's essentially it's being treated less favourably because of a legally protected characteristic. And there are a number of different types of discrimination, which I'll be going through. We've got direct discrimination, indirect, associative, indirect associative, perceptive, and finally discrimination arising from a disability. So there's a fair amount to get through here. So there are 9 legally protected characteristics set out in the Equality Act. These include sex, someone's race or nationality, someone's religious or philosophical belief. So some examples of philosophical beliefs could be veganism, for example, or climate change. Someone's sexual orientation, their age, if they're disabled. So the Equality Act has a definition for a disability, which is a physical or mental impairment that is likely to last or has lasted 12 months or more, and has a substantial adverse impact on their day-to-day activities. So providing that someone's condition meets that definition, that they're likely to be disabled under the Equality Act. There are some conditions that are automatically classed as disabled, for example, HIV, cancer, multiple sclerosis, and visual impairment. Gender reassignment also covered, as well as those that identify as non-binary or gender fluid. Pregnancy or maternity. And finally, we have marital status or civil partnership. So those are the protected characteristics in the Equality Act. So how much can someone win if they go take an employer to a tribunal for discrimination or harassment? But actually, there is no limit on compensation for discrimination. It is open-ended. Unlike unfair dismissal, where there are caps for how much someone can win, there is no cap on a discrimination claim. So it's made up of an unlimited amount of loss of earnings plus a potential injury to feelings award. And these are based on a scale from around £1,000 for the lowest, least serious, to up to 58,700 for the most serious discrimination claims. Now, the biggest ever discrimination award in the UK was an NHS surgeon called Dr. Eva Michalak, and she won just under £4.6 million. This was for both race and sex discrimination and victimisation. And essentially, she was bullied during her time in the workplace, harassed and discriminated against when she took maternity leave. Her colleagues and managers in her department had put together a Get Eva Out campaign. They'd made up complaints about her. She ended up being suspended for over a year until eventually she was dismissed. The reason the award was so high was that they found actually the sort of discrimination and abuse she suffered had been so psychologically damaging to her, she would never be able to work again in that role. So her loss of earnings was for the rest of her life, adjusted for inflation, pension contributions, etc. So yeah, it added up to just under 4.6 million of taxpayers' money that she was awarded. So the first type, and probably most obvious type of discrimination, is what's called direct discrimination. This is essentially treating someone less favourably than a comparator in another protected group. So someone with an X characteristic treats someone with a Y characteristic differently, less favourably. So this could be, for example, not offering a promotion because an employee is considered too young. So this would be age discrimination. Rejecting an application from a female because it's believed men have better technical skills. So this would be sex-based discrimination. Or being disciplined for a mistake at work because you are black and a white person wasn't. So race discrimination. So that one's pretty straightforward. Now, knowing that, we then have another type called indirect discrimination. This is defined as a policy or procedure that's applied consistently to all, but has a disproportionate effect on a protected group. So some examples of this could be a compulsory out-of-hours training sessions. The reason this could be indirectly discriminate, it could be to a female. Judges ruled that females have a higher burden of childcare responsibilities. So actually, by making a rule that everyone has to attend this out-of-hours training session, females would be disadvantaged by this due to childcare. For example, is a company-funded party at a nightclub, so that a number of protected characteristics could be disadvantaged to that. It could be disability, for example, if someone couldn't drink alcohol. This could be religion, if someone's religion meant that they couldn't be in a nightclub, or even age, for example, if you had younger employees that couldn't attend. So essentially, you're putting in place a rule that you believe is fair for everyone, but actually it disadvantages certain individuals due to their protected characteristic. If we look at the picture, for example, this could be in your workplace. If you had a multi-story building with only stairs and no lifts, whilst you're not saying that no one can come in directly, it is not possible for someone that, for example, in a wheelchair to come in. So this would be indirectly discriminate. And we'll talk about later on the situations where actually you can justify some kinds of indirect discrimination, because clearly there are workplaces that don't have lifts. Next example, we talk about associative discrimination. This is relatively straightforward in terms of actually you're not discriminating against someone for their own protected characteristic, but for their association with someone else from a protected group. So if we look at this image here, for example, a mother that is discriminated against their association with a disabled child. And there was a famous piece of case law on this called Coleman versus Attridge Law. Essentially, Miss Coleman was the carer for her disabled son. She was called lazy by colleagues when she'd asked for extra time off to care for her son. She was denied a flexible working request, even though other employees without disabled children had been granted it. And there was also an allegation made she used her child to manipulate her working conditions. And no surprise, it was ruled that she was discriminated against due to that association with her disabled son. Now, the most mind-blowing one is a recent addition to the Equality Act, which is indirect associative discrimination. I'll be surprised if you understand this the first time, because I definitely didn't. But it's essentially an individual who's not necessarily associated with the initial victim of discrimination, nor do they share the same protected characteristic, also suffers a disadvantage from the policy rule or decision, the disadvantage to the initial victim due to their protected characteristic. So yes, mind blown, I know. The way I have seen it described, which I liked, is called discrimination by ricochet. It's almost, although you're not aiming at that individual, the bullet ricochets and hits that person. And then the piece of case law that brought this in was in Bulgaria, I believe, and it was a heavily Roma populated area. An electricity company had decided to put the electricity meters another meter or two higher than other areas through ultimately a discriminatory belief that the Roma population would tamper with the equipment. Now, it wasn't actually the Roma people that made a complaint. It was the non-Roma individuals that were also disadvantaged. So they'd almost had that discrimination by ricochet through the electricity meters, even though it had been aimed at the Roma people. This could also be similar to our situation we talked about an out of hours meeting or training, where generally it's been ruled that females have the higher burden of childcare, but actually a father could still claim on that through this indirect associative discrimination due to suffering the same detriment, even though statistically it's more likely discriminatory to females. I hope that makes a little bit more sense than it did when I read the first definition. And a nice easy one then, we've got perceptive discrimination. And this is essentially where someone is discriminated against for a belief that they have a certain protected characteristic, even if they don't. And the famous case law on this was English versus Sanderson Blinds. Essentially, this was a male, Mr. English, that joined Sanderson Blinds. He grew up and he went to a relatively posh boarding school and was from Brighton and was well spoken. And actually, he was teased and ultimately harassed by colleagues for his perceived sexuality. They believed he was gay when in fact he was straight and he was married with kids. But he was still able to claim discrimination, even though he didn't have that protected characteristic of sexual orientation, which the harassers believed he did. And then finally, we've got discrimination arising from a disability. So we spoke about the definition of a disability earlier. Now, this is where actually someone is not necessarily discriminated against because they have that disability, but this is because of something that arises from or something that is a result of that disability. This could be actually if someone has a high level of absences due to that disability, so where they might have to go to regular hospital appointments. This might be someone's conduct or someone's behaviour due to the medication that they're taking. This might be that their disability means they need more regular rest breaks or toilet breaks, and they're discriminated against because of that. They're not allowed to go, for example, as much as needed. Or they're stopped from entering somewhere because they have an assistance dog due to visual impairment, for example. So none of these examples are actually discrimination based on the disability itself, but is something that is arising or something that is coming out or that results from the disability. This might also be in the workplace quite common, where someone is underperforming due to their disability and they're treated less favourably because of that performance that comes from the disability, or they act in a way, they commit some sort of misconduct due to their disability. So can we ever justify any of that, any of the types of discrimination I've spoke about? Well, yes, actually, there are some circumstances where we can justify it. So we can justify direct age, or we can justify indirect discrimination, providing it's a proportionate means of achieving a legitimate aim. That's an important statement there in law and in any defence to a tribunal. Essentially, you'd have to show that your actions were objectively justified and that you had a legitimate aim in what you were trying to achieve by doing the act of discrimination. So some examples of this could be a genuine occupational requirement. So, for example, if you were recruiting for an actor for a film or a production, and you might require a certain protected characteristic, you might require a certain sex or race, for example, for the authenticity of that performance. That might also be the same in a restaurant. If you had a Chinese restaurant, for example, you might be able to you'd be able to advertise as a genuine occupational requirement that they needed to be of a certain ethnicity for the authenticity of the restaurant. Interestingly, you could do that for front of house, but you couldn't do that for back of house, because there's no reason why a chef that was not seen by the customers would need to be of a certain race. Also, the national minimum wage exemption. So actually, on the face of that is direct age discrimination. You're paying someone less because they're younger, but this is an exemption. Although Labour do want to eventually get rid of this, currently those under 21 and on apprenticeships can be paid less than those 21 or over on minimum wage. Service-related benefits. So there is an exemption for up to 5 years. So, for example, holiday, where if your organisation, you might reward someone with an extra day of holiday for each year of their service. Now, you can do that for up to 5 years without any sort of reasoning. After that, you'd have to show that actually what you were doing was a proportionate means of achieving a legitimate aim. So you'd have to show some evidence that actually rewarding someone for being with you for 10 years has some improvement in quality or performance of the organisation. Otherwise, it could be age discrimination because a younger person wouldn't be able to have racked up that level of experience. Redundancy payments, again, direct age discrimination. The older you are, the more entitlement you are, the more you're entitled to for a redundancy payment. And health and safety reasons. There might be some roles, thinking here military or something more physical, or actually there are requirements with age why someone couldn't do that role. There's a good piece of case law on justifying discrimination called Dinser versus Serco. And Mr. Dinser, he was a Sikh prison officer, and he'd requested to wear a kirpan, which is essentially a ceremonial dagger, whilst he was on duty. Unsurprisingly, he was refused on the grounds of health and safety by his employer, and he brought a claim of indirect religious discrimination. So on the face of it, it is indirect discrimination. They've put in a place a rule that says nobody can wear daggers whilst they're on duty, and he suffered a disadvantage due to his religion, if his religion requires that he wear one. However, the organisation's defence here would be that actually, although it is technically indirect discrimination, it's justified, and they had a proportionate means of achieving a legitimate aim. So their legitimate aim was keeping the prison safe, and their proportionate means was to not allow anyone to wear daggers. So the tribunal agreed, and the claimant's case was turned down, as it was a justified reason. So moving on to harassment then, which is different from discrimination. So harassment is defined in the Equality Act as unwanted behaviour related to a protected characteristic that has the purpose or effect of violating a person's dignity or creating a degrading, humiliating, hostile, intimidating or offensive environment. Now, really important here to sort of define the distinction here between purpose and effect. And this is why the banter defence very rarely works with harassment. Ultimately, more weight is put on the effect the unwanted conduct or behaviour has on the individual as actually compared to the purpose. You know, if the purpose was a joke, that's almost irrelevant if the effect was the harassment violated a person's dignity or created a degrading, humiliating, hostile, intimidating, or offensive environment. Now, the harassment has to be related to the behaviour has to be related to a protected characteristic in order for it to be harassment. If it's not, it's likely to fall under general bullying. A few examples of case law. We've got Brown versus Young, Young and Co.'s brewery. So this related to a black pub worker that was told he looked like a pimp when he was wearing a promotional St. Patrick's Day hat. And he took his case to tribunal and said that he'd been harassed based on the grounds of race. And the tribunal agreed, and they accepted that the manager had used the word pimp because the claimant was black, that the word was insulting and undermined him and created a humiliating, hostile, intimidating, offensive environment. And another example is Mann versus NSL Limited, also a race harassment case. Mr. Mann, he was an ambulance care assistant, and he'd used the N-word in front of three white colleagues. So he'd argued actually that he didn't intend to offend anyone and viewed the term as a local street talk. Actually, he wasn't unaware that anyone else was listening. And despite his apologies, they agreed when Mr. Mann was dismissed by his employer that the dismissal was proportionate response to that, and actually regardless of the fact that the people that were offended and had created a degrading, humiliating environment for it, despite that they were white, they were still entitled to feel harassed by it as it was related to a protected characteristic. So harassment doesn't apply for some reason for pregnancy and maternity or marital status in the Equality Act. However, you could still be, if someone was harassed based on their pregnancy, it would fall under sex-based harassment anyway. Actually, it doesn't have to be directed at the claimant. So like we heard with the Mr. Mann example, that could be two individuals talking in an offensive way, and there's a third party there that hears that and is offended if the conversation is related to a protected characteristic and is offensive. So that what we spoke about is harassment based on protected characteristics. Then another specific example in the Equality Act is sexual harassment. And very similar definition, however, this is unwanted conduct of a specifically sexual nature. So it has the purpose or effect of either violating a person's dignity, creating an intimidating, hostile, degrading, humiliating, or offensive environment for the person, or actually it could be less favourable treatment because the employee either rejects to that advance of sexual harassment or submits to the unwanted conduct. Now, there's a new protection, as I'm sure many of you will be aware, that came into force at the end of last month that we'll be speaking about in a moment, that puts a higher responsibility on employers to prevent this. However, sexual harassment was already in the Equality Act, so there was protection prior to October this year. So what is unwanted conduct of a sexual nature? Well, the Equality and Human Rights Commission lists a number of examples in their guidance. So this could be sexual comments or jokes, displaying sexually graphic pictures, posters, or photos, suggestive looks, staring or leering, propositions and sexual advances, making promises in return for sexual favours, sexual gestures, intrusive questions about someone's sex life, sexual posts or social media contact, sexual rumours, sending sexually explicit emails or texts, and unwelcome touching, hugging, massaging, or kissing. This new duty is part of the Worker Protection Amendment of the Equality Act 2023, which came into effect just this October, 26th of October. And as I said, it puts a new duty on employers to take reasonable steps to prevent sexual harassment of their employees. It's very much a preventative duty. It's very much about taking action now to stop this from happening rather than what you do after it happened. Actually, it's very much a shared role for all of your team, So everyone is responsible for cutting out this behaviour, as for intervening when they see it and making the workplace free from sexual harassment. It's very much about changing the core culture of the workplace. What this new duty actually does is it gives power to tribunals to increase claims. So we talked about those unlimited claims that people can make through loss of earnings and injury to feelings award. So what a tribunal can actually do is anything that a claimant wins, if you as an employer have not taken steps to prevent sexual harassment in the workplace, if you've not got a policy on sexual harassment, if you've not given training to your staff, if you've not done a risk assessment, they can increase that award by up to 25% on top of what they've already awarded. So it's really important that you as employers understand this duty and take actions. All of our retained clients, some of which are on this call, I can see, will have received guidance from us. They will have received policies as part of our service. They will have received a risk assessment and guidance on how to complete that. And the other aspect of discrimination is what's called victimisation. Now, I find the term quite unclear and see it often thrown around as a term for any sort of less favourable treatment, but it has a specific meaning in the Equality Act. And actually, it'd be better known as retaliation, as what they call it in America. But essentially, it's treating someone less favourably or subjecting them to detriment because they have made a complaint on the Equality Act basis, or they've supported someone. So if someone has raised a grievance for discrimination or harassment, and then that person is ignored or cold shoulders or left out or dismissed ultimately for that, then it would be considered victimisation and would be automatically unfair. So yeah, it's really important that even if we don't believe someone's complaint or it's not proven, we still, we don't treat them any less favourably. This is not the case if we know that they've raised it in bad faith. So if someone's raised a complaint maliciously and we can evidence that they knew it was a lie and that it was a lie, then actually you can still discipline someone for doing that. But if they've raised it in good faith, i.e. they genuinely believe that it happened, they shouldn't be treated any less favourably because of that. So the Equality Act itself, 2010, prior to 2010, it wasn't just a free-for-all. There were a lot of laws in place to protect employees from discrimination. You had the Equal Pay Act, the Sex Discrimination Act, Race Relations Act, Disability Discrimination Act, but they were sort of all over the place, lots of different pieces of law. So what the Equality Act did was consolidate and bring those all together. It also outlawed pre-appointment health questionnaires. So essentially asking people for their health data and disabilities prior to employing them. It made this unlawful unless you could justify why you needed that for health and safety reasons. This again was to stop any discrimination where people might choose not to employ someone or give them an interview if they've seen they had a disability or from a certain background. It also added a concept called positive action, positive discrimination. This is essentially, actually, if you're looking to make your workplace more diverse, you've got a certain a lack of certain protected characteristic groups. If you have two candidates that score exactly the same, so you've objectively interviewed them and their score is exactly the same, you could hire one on the basis that actually you were trying to improve an underrepresented group, but they would have to score exactly the same. You couldn't employ someone that scored worse than someone else based on a protected characteristic. And there's been lots of these articles in the news and cases, the RAF being a big one, where they'd found to have discriminated against a lot of white applicants because they hadn't progressed their application and they'd chosen someone of a different race who had scored lower than them. So this obviously is discriminatory towards the white applicants. So I added these new concepts that we've spoken about. So perceptive discrimination, where you believe someone is of a certain protected characteristic, even though they may not be, they're still protected. Associative discrimination. So we talked about the example of a mother who was discriminated against for caring for their disabled child. Discrimination arising from disability. So again, this is around someone's potentially their conduct, their absence levels, their performance, that actually is a caused by or arising from their disability, but not discriminating on their disability themselves. Again, this is one of the ones that can be objectively justified by the proportionate means defence. So someone that is underperforming in their workplace that has a disability, whilst yes, you do need to make reasonable adjustments, if their performance level is not tenable for you, you are still able to dismiss them fairly, providing you've looked at adjustments, you've got medical evidence, and actually you cannot keep that level of performance, and therefore dismissal would be a proportionate means of achieving a legitimate aim. Then we spoke about indirect harassment. So actually, although the harassment is not aimed directly at you, you are still offended by it. It still has the effect of creating a humiliating or offensive environment. Then it did add in third-party harassment. So actually where you're harassed by someone that doesn't work for you while you're working. This was took out in 2013 as it was found to be very hard to control. However, it has been re-added as part of the Worker Amendment Act for sexual harassment. So actually there is a duty now to prevent third-party sexual harassment in the workplace. This could be, if you're a bar or a restaurant, this could be customers that are sexually harassing staff members. This might be another employee from another company at a work conference that sexually harass one of your workers. So the duty requires you to take steps to prevent that where it's possible. Did you know actually discrimination can often be unintended, and it's a lack of ignorance of the law where this can happen? Often it can be a positive intent. For example, if you're bending one of your policies for a certain employee, you might give them more time off sick than your policy allows as you're trying to do something nice. And then actually you decide for another individual of another protected group that you are not going to change your policy. And then suddenly that they could give rise to a discrimination claim that they've been treated less favourably because of that protected characteristic. Actually, all the employees really need to do is show that fact. They need to show a prima facie case of the discrimination. So they need to show, actually, I'm X, I was treated less favourably than that person because they're Y. And then suddenly the burden of proof switches, and it's you as an employer that needs to justify why you were treated, why that person was treated differently. What objective reasons did you have for offering that person more sick leave than your policy allows? So that might be due to their length of service. It might be due to them being diagnosed with cancer, for example. You've got to make sure that it's not a discriminatory reason that you've done it for, and it's important that you document it so that you've got that as evidence if someone ever did try and make a claim against you. Because through lack of evidence, a judge will look at it and go, well, actually, in the absence of any other explanation, it must be discrimination. And the other evidence that you'd have to keep, of course, if it was some sort of indirect discrimination, that it was a proportionate means to a legitimate aim. So we spoke about the Dinser versus Serco case and the Sikh prison guard, and actually, it would be important to document why that request was turned down, what the health and safety reasons were for not allowing it. And interestingly, in employment law, tribunals look at evidence and cases are judged on the balance of probabilities rather than in criminal law, where something has to be beyond reasonable doubt. So we think of criminal law being beyond reasonable doubt. That's almost, the judge and jury would have to look at saying that there's probably 95, 99% that this did happen. Whereas in employment law, it's much more relaxed. You only have to prove or have to show on the balance of probability that something happened. So that's probably 51%. It was more likely than not that something did happen. Don't know if any of you are football fans, but back in the day, I'm a big Chelsea fan, and there was a case around our player called John Terry, who'd allegedly racially abused a black football player on the pitch. And whilst in the criminal case, he was found not guilty because there wasn't enough evidence to prove that he had racially abused the player beyond reasonable doubt. He was found guilty by the FA disciplinary panel and stripped of his England captaincy because they did judge that on the balance of probability he did do it. So there was a lower burden of proof in employment law. And actually, it's not just you as employers that can be liable. So a claimant could take the individual employee to a tribunal for discrimination claims, and they could be financially liable where that claim is upheld. But likewise, you as employers can be held vicariously liable for the actions of your employees. So if they've been discriminatory or if they've harassed someone, it could be you that go to court, and often is. What you can do is you can create a statutory defence by making sure that you've got a clear policy that shows that harassment and discrimination is not acceptable, and that you've trained your team. So you've given them training like I'm delivering today to make sure that they're totally aware that this is not acceptable in the workplace. Then you can go, whoa, this person knew that they shouldn't have been acting this way, and therefore it should be them that is in the dock, as to say, as opposed to you as an employer if you were really unaware that this had happened. And the infamous banter excuse very rarely holds up. Something intended as friendly banter can be seen as harassment if it has the effect of creating that intimidating, hostile, degrading environment for the individual and could give rise to a claim. Actually excluding someone in the workplace, excluding them from work lunches or social events can give rise to a discrimination claim if they're of a protected group, even if that was not the intent. When we talk about disabilities, actually, they're not always obvious. We talk about hidden disabilities and mental health conditions that can often, and there's more and more case law around mental health being a disability, neurodiversity, ADHD, all of these conditions actually where they do affect someone's performance, someone's conduct. And you do have to be really careful if someone cites this in the workplace that you don't act in a discriminatory way and you make reasonable adjustments. Cool. And yeah, that is the end of my session. So I believe Steve now has some content to share. So I'll stop sharing my screen.
Good stuff. Thank you very much, Luke. Let me just share my screen as well. So there we go. Excellent. So hopefully you can see all that. Okay. Thanks, Luke. Some great stuff in there as always. As I mentioned earlier on in the session, I wanted to show you some of our tools and features of our software that will help really sort of directly with some of the issues that Luke has raised during his part of the session. Rather than jumping straight into those specific tools, though, I thought it would be a useful idea really to give you a quick 2 or 3 minute overview of all of the features that are included in our HR Planner system. This will just provide a little bit of context. So with any HR software, you would expect there to be absence management module, and absolutely there is. So employees can use the system to raise and submit leave requests for authorization or not, as the case may be. There is a company calendar for employees to view as well, so they can see when their colleagues are in and out of the office, and be able to make sensible decisions about requesting leave for themselves. And behind the scenes, that there are numerous tools for the HR team to just better control how absence works within the organisation. So rules around whether or not allowances for holiday are given in days or in hours, whether or not unused leave can be carried over from one year to the next, controls about how many people from a department can be away at any one time. So these are all tools in the background that the HR team have access to just better manage absence management. There is a company contact directory as well. And just whilst I'm on here, by the way, clearly I'm not showing any data I shouldn't. This is a test or trial data, as it were. And incidentally, I'm logged in as a chap who has full access to all data and all tools and systems. That there is quite good quality control over who has access to what information. But for the purpose of the demo, I'm logged in as somebody who has access to everything. So the company directory here, the contact directory, is really aimed in its sort of default settings as to sharing work contact information. So colleagues' names, email addresses, phone numbers, that sort of thing. But beneath this, as I mentioned, I've logged in as somebody who has access to more detailed information. So normal employees can't do this. But at the next level down, there is clearly contact information and more personal information about each employees in the system. And so here on the personal profile in the company directory, you've got information around home addresses and home contact details and so on. There's emergency contact details, which you can capture as well. One of the great things about our HR planner system is that all of these fields are customizable. So you can add in any fields you wish to capture information that's important to you. And I'll come back to this a little bit later with those protective or protected characteristics as well. You can add in fields and sections to capture things about known medical conditions and gender and nationality and that sort of thing too. For each employee, there's a salary section too, so you can track salary for employees over time, and again capture information such as bank details as well, if that's the sort of thing you need for each of your employees. There's an expenses module where employees can raise expense claims. They can add expense items. They can upload receipts and submit these expense claims to whoever it is that needs to authorize them. And whether that's to their line manager or straight to accounts, you're in control of where these requests go to for authorization. And as expenses are completed, there's a complete expense history on the employee's records as well. Documents within HR Planner, there's a couple of areas of documents actually. First is here on each individual employee's record. You can upload documents that relate to this specific employee. So you may want to keep their employment contract on file, disciplinary letters, doctor's notes, that sort of thing. But there is also for want of a better phrase, a public folders section, the public being clearly your employees rather than the general public, as it were. But here you can upload and store and make accessible to your staff your HR handbook. So any advice and documents around leave policy, sick leave, parental leave, and so on, and disciplinary process. Great thing about HR Planner is that it is a web-based system. So as long as a user has access to the internet, they can log into the system with their username and password. So they can access this information at home 24/7. It can be on a mobile device traveling around. And within this documents area as well, you've got full control of what employees can see. So it may be that you want all of your employees to be given access to the HR information, but actually our financial and legal staff, I just want my senior management team to have access to this. But documentation, there's no limit to the amount of documents that you can upload into the system and give access to your staff. Two other areas. One is the reporting. In fact, there's two areas of reporting where you can do this. So clearly you've got all of this data and information in the system. It's good to be able to get that information out. And here on the dashboard is one area in which you can do it. These things here are called widgets, and each user is in control of these widgets, and they're basically going off to the database, capturing information that you tell it to capture and bringing it back and putting it in this visual format. As I mentioned at the beginning, this chap Bob, who I've logged in as, has access to all the data because he's an administrator level user, so he can create widgets that show sick leave across the company as a whole, and the same with holiday as well. So we can see trends, we can see spikes in absence, and be forewarned of what happened last year and this year. Clearly, if I'm an employee who doesn't have access to all of the company sick leave, my graphs are going to look a little bit different. So as well as your widgets here, which are sort of real time and are constantly updating, you have a report section too. And there's a lot of standard reports built into the system, which are really easy to run. There's nothing technical about these. You can apply filters and run a leave summary report, for example. If I just expand that a little, and there we go. So here you can see just a quick report, which is showing me my employees and what leave allowance they have, how much they've got remaining. Something, no doubt, this time of year is something that's quite important to try to see. But you can create your own reports as well. So not only the standard reports in the system, and I'll show you a little later, creating your own reports and saving them in the system to run at any time. And there's also, just finally, on the sort of broad overview, the feedback area, and this is where you can, as an administrator, create questionnaires and then distribute those questionnaires to employees to respond to. And these are useful for anything from surveys around working conditions or working from home, employee satisfaction type surveys. You might use them also for new starters, making sure that they've provided information for you as you need it to be done, or leavers, asking them questions about working for the organisation and so on. And with the responses, clearly they're distributed electronically. With the responses, I can see individuals' responses to how they've answered the questions and how they feel about things, but I can also see how the organisation as a whole has responded to those. So it's really useful for gathering that information and seeing where you as a company are with those. So specifically, some of the things that Luke was mentioning today, and some of the tools in here which will help address those. Firstly is the attributes that you can apply to employees and information that you can capture. So we were talking about protected characteristics. So here, for example, I've added in some fields where you can capture the gender of your employees, their marital status, and so on. And you can create lists for people to choose their nationality and capture their date of birth and that sort of thing. You can allow your employees to update their own information. So there is quite a good level of self-service built into this, having your employees keep their own information up to date. And of course, you can run a report to capture that or show that information. So here I've added a report, which, if I can just run that very quickly, once again, you can see here, this is just a report of my employees. I can very quickly get their date of birth, their nationality, and so on. And with that data, I can export it into Excel if there's things I want to do with it, but there are tools within the report designer to sort that information, to create charts and graphs as well. So it's a really useful tools for capturing those protected characteristics. I think you can also use the feedback section as well for creating questionnaires. You may be capturing whether or not, or the level of knowledge, if you like, of your managers with respect to some of the things that Luke was mentioning today. So creating a questionnaire just on equality and diversity. You can ask just some simple questions for your managers to respond to. So what is their knowledge? If it needs improving, what's the best way of doing that? And asking for some comments as well. So really useful there for judging what your current knowledge is, how best to improve it, and what sort of format that the consensus is for that sharing of additional information to be had. And of course, you can upload and host documents relating to the issues as well. Also, we were talking about flexible working. So yeah, a couple of tools in here which are useful. Within each employee, it's really simple to adjust working patterns. One of the things that's become more common over the last 18 months, 2 years or so, is yes, you've got your full-time staff, yes, you've also got your part-time staff, but there's definitely an increase in people who will want a different working pattern during school time and during non-school time. So it's very easy for you to adjust people's working patterns to work different hours. And what's really useful in this situation is be able to bookend working patterns. So from January through to the end of the March, I might be working full time, but then during those Easter holidays from the end of March through a bit of April, I want to reduce my hours and I'll be working this pattern. But then come the beginning of April, once the kids go back to school, I'm going to return back into my full-time working pattern. So it's easy to create customizable working patterns for employees. And of course, you can add in specific leave types. So yes, you've got holiday and sick leave and absence and so on, but you can add in any additional leave types you wish. And common examples of those, yes, training and maternity leave, but if we're talking about flexible working, things like carers leave, parental leave, and so on, you can add those into the system, and you can control who has access to those to be able to book them off. It may not be applicable to all users, so good flexibility in the leave types that address that. And finally, the discrimination around leave requests. That there's often situations where people or employees perhaps feel that their requests are being declined more often than somebody else's, maybe, or colleagues' requests, despite being submitted after mine, tend to be approved, but although my request was in beforehand, it seems to be declined. Within HR Planner, there is an audit trail for all events and all tasks that are carried out in the system. So if you are presented with those situations of employees feeling that their requests are being declined, it's very easy to go to an employee's audit trail and be able to look at a request from an employee, and you'll notice that everything is time and date stamped. So we can see straight away when that request was submitted, we can see who authorized it, or in this case, we can see that it was declined, and we can see who declined it and when they did that. And what's more, you can see the reason that was given for declining that request. It's the same with the time and date of when requests were submitted as well. So if you're presented with those situations, there's always this electronic footprint, if you like, that is there to refer to and get the facts of the sequence of events. And of course, this audit trail, it's not editable. You know, employees don't have access to it. It's not something they can delete and modify. It's just an administrator that can view the actual sequence of events of those requests. So there's just a couple of examples, I think, where the tools we've got within HR Planner can address those issues that Luke has raised. And with that, really, I know that was quite a quick tour and not in too much depth. But what I will be doing over the next couple of days or so is just dropping an email to all of the attendees. If there's anything we can do to help, whether you're new to HR software and having this for the first time, or indeed if you want to, you are using HR software and want to move across, I'm sure there's things we can do to help. Happy to organise a one-to-one session. We can take a little bit more time and go into a little bit more depth as to how we can help. So with that, if there's any questions that people wanted to put into the chat, we're happy to answer. I don't think there are any at the second, are there, Luke?
No, I've not seen any, but by all means, if anyone has any questions on anything I've spoke about, please, come off mute and ask me if you can, or pop something in the chat.
Good stuff. Is there anything else you wanted to add at all, Luke?
No, I just think, the last bit you mentioned on there around, the audit trail, that's a really important part of any kind of decisions where you do go against your policy or there is variation in decisions, making sure you've got an audit trail of your objective reasoning. So having something there is really handy in that tool to document it.
Yeah, absolutely. Yeah, and I think that the sort of things you were saying about people's understanding of scenarios and situations, documentation on that, which is available to all of your staff on the system there for them to review and read up about. I think that's quite useful too. So good stuff. So with that, thank you everybody for attending. We will drop you an email with a recording of this either later on today, more likely tomorrow, I would expect. So look out for that, and also look out for our future sessions as well. As I say, they should be in the new year. We'll have some more of these scheduled too. So thanks everyone. Have a good day.
Thank you. Bye.